Hi, everyone. This is your favorite realtor, Norm O'Neill with Keller Williams Realty, callnorm.com. Today, I've got a great guest joining me. It's Kyle Manikas from Virginia Estate Planning Lawyer.com. And we're going to talk about probate, estates, real estate, something that comes up a lot in this day and age, and Kyle has a ton of experience with this, so I'm really looking forward to the conversation. Let's jump right in. Welcome, Kyle.
Well, thank you, Norm. I appreciate you having me. I always take the opportunity to talk to folks when they're interested in this subject. It's something I think everybody can benefit from, so if someone has an interest, I'm always happy to discuss, so thanks for inviting me today.
It's my pleasure, my pleasure. I think this conversation, and my clients definitely want to hear what you have to say about this, and I know your clients do too as well. Can you talk a little bit about the real estate and probate connection? A lot of times I know that when folks are going through this, there is real property, real estate to sell. So when someone inherits a home in Virginia, what's the first legal step that they should take?
Yeah, so it partly depends on how that home is owned. So the first thing, obviously, that determines how a home passes is the deed. So for husbands and wives, normally they take what they call tenancy by the entirety, but it has a right of survivorship, all right? And that right of survivorship means that when the first spouse dies, the property by operation of law automatically passes to the second spouse. It bypasses any probate or anything of that nature. It goes directly to the spouse just by operation of law. And that's an ideal situation. Now, if somebody inherits a piece of property and it's not in a trust, then it has to go through a process called probate. You know, we haven't talked in too much detail about probate, but the best way that I can describe probate is it is a lawsuit you file against yourself after death with your own money for the benefit of your creditors. That sounds crazy, but that's exactly what probate is. And that's why so much of the planning that I do is advising people on what they need to do to avoid probate. Because, you know, one, it is a process that encourages litigation. The first thing that your executor does, and if you haven't named an executor, that means somebody you know has to come forward and volunteer for that. It's a lot of work. I mean, the first thing they have to do is, you know, one of the first things is provide a list of all your relatives to the court. And it may be relatives that you don't like, you haven't communicated with, you don't want to have anything to do with your property or your family, but they're going to get a notice in the mail in probate that's going to say that there's this estate, they may be entitled to money, and if they think they are, they should come file a claim, right? So right away, we're starting out with a process that is encouraging fighting and litigation. On average, probate takes about 8 to 12 months, and you know, again, it's a creditor-centric process, so it's designed to preserve the estate. So, you know, things are more or less frozen for that period of time so that the creditors have reasonable opportunity to file a claim against the estate. And of course, then the creditors are paid first and your family gets what's left over. So if you inherit a piece of property that's going through probate, that's great because you're inheriting property. It's not great because you're going through probate. Probate is expensive. The legal fees are expensive, the court costs, the appraisals, the professional fees, those generally eat up about 6 to 8% of the fair market value in a good scenario. Okay, I've seen scenarios where, you know, probate's eaten up at least half of the value of the estate, right? When there's any type of dispute. So there's going to be costs, there's going to be delays. Now the question is the home paid for? Who's paying the mortgage in the meantime? These are all things you're going to have to work through the executor on. Now, the executor may be able to file a motion and get authority to sell the home in the before the probate is concluded. But again, it's a court process, right? And it's involved and it's expensive. And when you get that piece of property, you're getting it outright in your own name, right? It's as if you went out and bought it. There's no protection there. Okay, now let me compare that or contrast that for you with a trust. So if that property was owned in a trust, there's no probate, there's no executor, right? That's a good thing. There's no court process. And all those legal fees and expenses and holes or hoops that you have to jump through, those don't exist. What happens is the property is in the control of the successor trustee of the trust. And if the trust indicates you are to inherit that property, then literally it can be done in a lawyer's office in an afternoon. It's that quick and that's efficient So,
and then they could be full owners that easy.
Yes. Now, the other alternative is that home stays in the trust and they are a beneficiary of the trust if it's an income producing asset. And then, you know, obviously, you know, they can get the income from that property every year and then capture the appreciation. The other benefit is they get the benefit of what they call the step up in basis for that property that's in the home. So in other words, if you know about
good
this,
things
right?
about this, tell us about it.
So if it is a revocable trust, and there's lots of different types of trust, but the trust we're talking about here is a revocable trust, right? And that's really what 99% of people use. There are irrevocable trusts, but you only use those if you need them for the purpose because you lose other benefits. So for instance, one of the benefits you get from a revocable trust is you get that step up in basis, right? So if one of your clients, purchased a home, an investment property for $100,000 and it's now worth $500,000 and they sell it, obviously they're going to pay taxes on that $400,000 they made. However, if they hold that home in a revocable trust, when they pass away, that home gets a step up basis to the fair market value. So in other words, that $400,000 that would have been taxed is capital gains is completely wiped away, and the children or the other beneficiaries can inherit that home capital gains tax free. Now, if it continues to appreciate after that point, then obviously they would be responsible for that. But it wipes away a lifetime of capital gains potentially, which is a huge benefit for the people that you're, leaving your property to.
Yeah, it sounds like any money that was any appreciation in the property since their relative, for example, purchased it, they received the property at the new value, today's market value.
Right.
So all of that appreciation it becomes tax-free.
Exactly
on
right.
a stepped up basis. What a huge savings.
Huge
Folks
savings.
are saving big money on this, right?
Huge money. It's probably the most significant way that we pass wealth to intergenerationally, and I hope that stays a feature of our tax code. But from time to time, people talk about eliminating it, and that would have huge implications. And that's one of those things where maybe not a lot of people would appreciate that at the time they passed it, but it would have a huge impact on people, I think, over the years.
Let me ask you this: if you're nominated executor, or if you're named by the court, or can the executor sell real estate before probate is complete, or would they have to have some kind of court order? How can families sell real estate if they need to sell it swiftly?
Yeah, it has to be done by court order. One of the least enjoyable jobs is being an executor because, number one, it involves a lot of work, but also it involves a lot of potential personal liability, right?
Oh,
so if the executor sells a home in the estate and then, for whatever reason at the end of the estate, there's not enough money to pay the creditors, the executor is personally liable for that.
Oh.
So yeah, you can sell a home in probate. You've got to have normally court permission to do that. But a lot of the times the executor doesn't, they don't want to unsettle things until they have a clear view of what all the obligations are.
Exactly. That makes sense. Well,
it's because of the personal liability issue.
Right. As you're talking about that personal liability, is there a time limit when a home can be sold, or a time limit that an executor administrator has to perform under?
As soon as the probate estate is opened, those assets in the estate are under the control of the court, and you really can't do anything without a court order during that time. And outside of a trust, that would be the only way that you could possibly change title to a piece of real property is through probate, and it's just not going to proceed until everybody's sort of ready. And how quickly it proceeds and what the timeline is just a function of how busy the court is at that moment. The average time is 12 to 18 months roughly, but during COVID it got much longer.
Sure.
So those type of things do have an impact on time.
Speaking about the timing, and this sounds like could be average a year, what are some of the most common challenges families are facing when they try to sell inherited real estate?
One of the things is that sometimes the property sits vacant, and as you know, with vacant property, things start to happen, and things are not kept up. Sometimes there's leaks, other damages, and so because of that, they're not getting the best value they can potentially for the property. And I think most of the time when you have a situation where an heir is not going to be continuing to live in the property and you're dealing with it under a will, that tends to happen a lot just because of the delays in probate. It really, if you think about the cost of what it takes to put a home through probate, it's a small fraction of what it costs to set up a revocable trust. So by spending the money to set up a revocable trust, you're making it back, tenfold sometimes or more, maybe 20-fold, maybe 30-fold. So just something to think about, especially with a situation where you have homes in multiple states, because then you're in a double or triple probate situation. You need a probate estate and a lawyer or law firm in each state that you have property.
Wow, that's something that I didn't know. What would you say the biggest mistake is people make when they're in this type of situation, when they're handling real estate through an estate or probate?
Yeah, well, I think a couple things. I think in general, the idea, and I know it's sort of been ingrained, that the idea that a will solves all of your estate planning problems, right? That's just been hammered into people. I need a will, I need that, right? But the fact is that it doesn't, especially in the real estate world, where you have high value assets that appreciate quickly. Probate is not the best place for them because of the expense, and because really, if you're building that real estate empire, you want to pass it on to somebody. And so why would you not want to pass it on in a protected legal wrap, right?
Yeah.
And that's an important point because under the common law, which is really what trust law is, it goes back to the law of England. You couldn't create a trust for yourself that gave you asset protection. In other words, I can't use my assets under the common law to create a trust that gives me asset protection, but I can use my assets to create a trust that gives somebody else protection, like my child, right? And so if you're doing this for your children, you're giving them and passing them on property in a way that is protected that they can't give themselves, right? That's only something you can give to a third party. And that's what makes it special, is that you're providing them that asset protection that they can't give themselves.
I love that. You know, as you're sharing this, again, it's so important for folks to talk with you, learn their options, and you're really talking about protecting family here, our relatives, your own kids. Thank you for sharing all this. I'm Norm O'Neill with Keller Williams Realty. Questions, concerns, hallucinations, call Norm.
I like that. It's great. It's a pleasure talking with you. And of course, save those questions because be happy to do this again sometime.
We'll look forward to that. Look forward to that. Thank you everyone for joining.